In one of my previous videos, I have talked upon that how to get a delay condoned by the court. But what if we are on the other side and we have to oppose the condonation? The other party is requesting the court for the condonation of delay and we have to oppose it strongly. So what are the Supreme Court rulings and arguments which we can use for opposing the same? Also, if the other person has used the Supreme Court rulings which I have referred in my previous video, still how can we use other Supreme Court rulings to harmoniously construct both of them in our favor? Let us see in this video. First of all, before moving forward, it is a very important question to deal. If every person is entitled for the justice, then what is the need of limiting the same with some deadlines of time by the provisions of Limitation Act? So what is the reasoning behind the law? The answer lies to a latest Supreme Court ruling of 2024, Delhi Development Authority versus Tejpal. In this case, Supreme Court held that the objective behind the law of limitation is that the rights of a person cannot be kept in a constant state of doubt, suspense, and uncertainty. Cases are like diseases. It must end one day. So the public interest requires the end of the litigation, which is being fulfilled by the law of limitation. And the Bombay High Court, in the ruling of Kumudini Ramdas Shah versus KM Modi, has given the philosophical concept behind the law of limitation that the sword of prosecution should not be kept hanging over an undefined period over an individual, number one. Number two, those who are lethargic should not expect the law to come to their rescue of their rights. Number three, because of the delay committed by the plaintiff, the defendant may have lost the evidence because of the delay in time. So the defendant cannot be expected to pay the cost of the delay committed by the plaintiff. However, I want to make it clear right now that the law of limitation does not destroy the right in itself. Right kept standing, but the law of limitation extinguishes the ability to enforce that right. This is the basic concept of limitation. Now, the relevant provisions of the law which we are talking today is the Limitation Act Section 3 and Section 5. Section 3 states if there is any suit or appeal or any application made after the prescribed period as per the Limitation Act, it must be dismissed. This is a general rule. Now, Section 5 is an exception that talks about the extension of the time period and the condonation of delay if there is any sufficient cause with the party, because of that the delay was committed in the given time period. So there are many rulings which has stated that there should be the liberal interpretation for the Section 5 condonation of delay, as stated by me also in my previous video. So how to oppose it? Now let us see the various rulings of Supreme Court. The first ruling of Supreme Court is a 2011 ruling, Lanka Venkateshwarlu versus State of Andhra Pradesh and others. In this, the High Court below condoned a delay of about 3700 days. Supreme Court set aside the High Court order and stated that there may be a liberal approach for the Section 5 condonation of, that is the condonation of delay section of Limitation Act. But that liberal approach or justice-oriented approach should not override and should not destroy the substantive provision of Limitation Act, that is Section 3. Because there is Section 3 in Limitation Act which talks about to dismiss it, we have to dismiss it. Either remove that law or follow it. Hypocrisy is not a solution. Now, next Supreme Court ruling is a latest 2024 Supreme Court ruling, that is Pathapati Subha Reddy by LRs and others versus Special Deputy Collector. In this, Supreme Court dismissed the special leave petition and did not condone the delay and held that in Section 3 there is a word shall which makes it mandatory. So it cast upon the duty on the court to dismiss the special leave petitions or appeals or suits or applications which are filed after the prescribed limitation period. And there should be no if and but for it. Because limitation law is a law for public policy. And if it is not followed and this litigation will not come to an end, so there will be a greater dichotomy that we, the human beings, will die one day. We are mortals. But these litigations will become immortal like God. There will be no end to it. Therefore, the Section 3 cannot be ignored. Now, next Supreme Court ruling is from the year 2014, Brijesh Kumar and others versus State of Haryana. In this case, Supreme Court held a very important point of law that if a person has got the relief of condonation of delay by a court, so other person cannot use that order as a precedent and cannot demand from the court the condonation of delay on the basis of equity. It is not a matter of right. Condonation of delay is not a matter of right, and no case sets a precedent. So by and large, condonation cannot be given on the basis of parity, equity, sympathy, and compassion. And the only exceptions are given, which are given in the Limitation Act, can be followed. Now, next Supreme Court ruling is Ramlal, Motilal, and Chotelal versus Reva Coalfields Limited. In this case, Supreme Court clarified that in section 5 that talks about the condonation of delay has the word may. It means the provision is discretionary in nature. So even if the litigant has showed a sufficient cause to the court that why the delay was committed by him, even then it is not a matter of right, and still the court can deny for the condonation of delay and dismiss his appeal or application. Now, next Supreme Court ruling is from 2007, Bhagmal and others versus Munshi by LRs and others. Now, Supreme Court held that Section 5 can be given liberal interpretation, no problem, but Section 3 has to be interpreted strictly, because the effect is that the Section 3, which talks about the dismissal if there is any delay, is a general rule, and Section 5 is an exception and should be used as an exception. It cannot be used by and large as a general rule. Supreme Court wants to convey in this. So it has to be, the section 3 has to be construed very strictly. Now next is a 2013 Supreme Court ruling, Basavaraj versus Special Land Acquisition Officer. Supreme Court observed that the effect of limitation law may be harsh to a party. But even being law is hard, it's the law and has to be followed. Till not removed, the law has to be applied with all its rigor, and there is no alternative to it. And if any court condones the delay and justifies that condonation on the ground that the court has applied various conditions on the litigant, still it is the disregard of the statutory provisions, because the exceptions laid down to Section 3 of Limitation Act does not provide for such act of the court that the delay can be condoned by putting some conditions on the litigant. Now next ruling is a 2024 ruling, Delhi Development Authority versus Tejpal and others. Supreme Court held that the word sufficient cause under Section 5 of Limitation Act does not mean a good cause. Sufficient cause means a cause in which the court gets entirely satisfied that there was an event or circumstance which didn't allow the party to file the appeal on time. Supreme Court further held that sufficient cause is a cause which occurred within the prescribed limitation period time. For example, the limitation period is 30 days. The Supreme Court will see, or any court will see, that what was the cause or what was that event or circumstance which took place within those 30 days which prevented the party to file the suit or appeal or any application. Any subsequent cause or any event or any circumstance which took place after the limitation period, howsoever important it is immaterial and cannot constitute the sufficient cause. So the route to the exception is very narrow as per the Supreme Court. So have you seen? The law is same, the condonation of delay, but it depends where we are standing, and we use the law, the elements of the law and the Supreme Court interpretations in our favor. So in this video, we have used the law and the Supreme Court interpretation to oppose the application of condonation of delay. But how to convince the court for condoning the delay? This I have covered in this video, which you can click right now to watch this video. See you in the next video. Thank you very much.